Good morning. Welcome to Brodie's autumn training programme. We're going to be presenting a webinar, The Emperor's New Clothes. So who's presenting today? Well, myself, Craig Watt. I'm a partner in Brodie's commercial litigation team. I head up our corporate dispute sector, which is increasingly very busy. We're seeing a distinct growth in corporate disputes over recent months and indeed slightly further back. These instructions cut across the whole spectrum of corporate disputes, for example, unfair prejudice petitions, directors' disputes, shareholder derivative actions, and joint venture disputes, and everything in between. I'm also joined by two of my colleagues from within the corporate dispute sector. First, Jared Oyston, who is a fellow partner within our commercial litigation team. Jared is English qualified, and he's resolved disputes in the corporate sector before the English courts and also utilising arbitration. So he will provide his own insight from that perspective. And secondly, I'm joined by my colleague, Peter Begbie, an associate within our commercial litigation team and within the corporate dispute sector. Peter's Scottish qualified, but I'm happy to say that he passed his SQE exams in the summer, so will shortly become dual qualified. So he'll be able to add an insight from both sides of the border. What are we going to cover? So we are going to deal with what was the shareholder rule and why it matters. What was this case about? What was the decision? What does this mean for companies? Does this mean that companies will never need to disclose legal advice? And can a shareholder still get their hands on legal advice? So that's what we're going to cover. So firstly, if I can pass over to Pete, what was the shareholder rule?
Thanks, Craig. Good morning, everyone. Jared's got the honour of explaining the reference in the title to the Naked Emperor shortly, so I'm going to set the scene. Have a look at what became known as the shareholder rule, which has been abolished now in the summer after almost a century and a half. So we'll look at what it was and how it came about. So essentially, the shareholder rule was an exception to legal professional privilege. I think most of you will be aware of privilege and what it is. Essentially, legal professional privilege comprises advice given by solicitors, legal advisors to their clients, and also a variation on that where there is litigation on the horizon or in tow. Privilege is a fundamental principle of civil litigation and public policy, and it provides an absolute right not to produce confidential communications with their lawyers, or in the case of litigation privilege, confidential communications made for the dominant purpose of litigation. So that would extend also to third parties. And until very recently, the shareholder rule had been regarded as providing an exception to the rule of privilege. Significant because, as I've said, privilege is a fundamental right, and the application of the rule prevented a company from asserting privilege against its own shareholders. Now, I should mention at this point that the concept of disclosure in England is quite different to Scotland. Here in Scotland, apart from some limited exceptions, there's no automatic right to disclosure of any documents, even documents relevant to the facts of a case. Instead, if you wish to see documents in the possession of your opponent, you have to make an application to the court. In contrast, in England, parties are subject to an overarching obligation to disclose all documents which are relevant to the case under their control, whether or not they're helpful or damaging. But ultimately, the position of a party served with a court order for recovery of documents in Scotland is in essentially the same position as a party in England when it comes to deciding whether or not to assert privilege. And so it's that assertion of privilege that this webinar is concerned with today, and to which the shareholder rule exception previously applied. And although the recent decision is not binding in Scotland, since the law of privilege is substantially the same north and south of the border, it's anticipated that Jardine will be followed here too. And that's a very long way of saying that we're confident that the court's decision and hopefully this webinar will be relevant to companies and their stakeholders, whether they're in Scotland or in England. So as you'll see from the slide, you have to go all the way back to the Victorian era to find origins of the rule and a case called Gouraud. For any geeks in the audience, the judge in that case was one Lord Chitty, who wrote the seminal work on English contract law. A little nugget of information for the geeks. The rule itself was initially justified on the basis that the shareholder had a proprietary interest in the company's assets and therefore, by extension, a proprietary interest in advice taken for the company that was paid for from the company's funds. And it might seem surprising given that the decision in Gouraud established what would go on to be widely recognised until recently as a general rule of law, that the judge, Lord Chitty, only relied on one case. That case concerned the Mayor of Bristol and the City Corporation of Bristol, who were suing the president of the Bristol Law Society. They were looking for an injunction restraining him from publishing statements casting doubt on the City of Bristol's title to some surplus land. The City Corporation had disclosed documents which recorded the opinions of counsel about the dispute, but claimed litigation privilege from their production. There's a distinction between disclosing a document and producing it. Essentially, producing the document means that the other side actually get to see it and not just to be aware of its existence. Well, Mr. Cox tried to argue unsuccessfully that since he was a ratepayer, i.e. a council taxpayer in Bristol, privilege could not be claimed against him in relation to the opinions of counsel because he had indirectly paid for that advice through his rates that he paid. And by analogy, with a similar rule that applies in relation to trustees, he suggested that Bristol City couldn't claim privilege in relation to the council's opinions. I won't trace back the origins of the trustee rule, very much taken as read, but as the Privy Council in Jardine noted, it's essentially based on two propositions. First, that the beneficiaries collectively had an interest in the due administration of a trust, and secondly, that they collectively own the trust fund out of which the legal advice is paid for. But the court in the Mayor of Bristol case dismissed that argument, but they commented that if the action were by Mr. Cox as a ratepayer against Bristol, for example, in relation to some matter about the raising of rates or to the expenditure of the rates, then Mr. Cox would have a right to see the legal advice. And it was these comments which the court in Jardine described as providing something of a stepping stone in the transposition of the trustee rule to the company shareholder context. You might be asking yourself what the relevance of the City of Bristol was here. Well, that is in fact a further analogy, because a city corporation, like other corporations which are created by statute or royal charter, was a proper body corporate, to use the legal terminology, and crucially had a legal personality that was separate from its members. So it's that which made it analogous to a limited company. And the Gouraud case was expressly decided on the basis that there was a true analogy in the company context with the trustee rule, on the basis that shareholders could be said to be the beneficial owners of the company's property, and therefore that the shareholders could be said to have paid for the legal advice of which the shareholder was seeking disclosure, even though the company was a separate entity, and because directors could therefore be said to be trustees, essentially, for the shareholders. Well, that was a false equivalence, as the court in Jardine has ruled, and indeed that position has not reflected the law in either Scotland or England in relation to the way that the separate personality of companies and their shareholders has been understood for about 100 years. And I'm sure that Jared will explain that in more detail as he touches on the case itself. Nevertheless, the shareholder rule was born and it remained a part of the law until June of this year.
Thanks, Pete. Well, I'll now pass over to Jared to explain what the Jardine case was about and what was the decision, which Pete may already have foreshadowed, but many of you will be aware of it anyway. So, Jared, what was the case about and what was the decision?
Thanks, Craig. Thanks, Pete. Good morning, everybody. So this case concerns a corporate reorganisation in 2021 within the Jardine Matheson Group, which is an Asia-focused investment business. And one part of this corporate reorganisation involved the amalgamation of two Bermuda companies, Jardine Strategic Holdings Limited and JMH Bermuda Limited, to become a new Bermuda company, Jardine Strategic Limited. And we've got a simplified version of that there on the slide. Now, under Bermudan corporate law, the way the amalgamation would work is that all shares in Jardine Strategic Holdings Limited would be cancelled and essentially replaced with shares in the new company, Jardine Strategic Limited. But if a shareholder voted against the amalgamation, rather than shares in the new company, that shareholder would be entitled to be paid by the new company fair value for the shares which were cancelled. And in this case, the shareholders of Jardine Strategic Holdings Limited who did not want to become shareholders in Jardine Strategic Limited were offered a fair value of $33 per share for their cancelled shares. And those dissenting shareholders disputed that $33 per share represented fair value. And they triggered the statutory mechanism that's provided for by the Bermuda Companies Act, which in such a situation requires the court to step in and determine the true fair value of the shares. So moving on to the next slide. So this dispute generated quite a bit of litigation, but the judgment we are looking at today concerned the right of access on the part of the shareholders in the litigation to legal advice which had been obtained by the Jardine Matheson Group. So specifically, when setting their fair value of $33, Jardine Matheson had obtained legal advice, as one would expect. And the dissenting shareholders sought disclosure in the litigation of that legal advice on the basis that it was relevant to the issue of fair value. And Jardine Matheson refused to make the advice available for inspection on the basis that it was covered by legal advice privilege. Now, it was common ground in the case that the advice would ordinarily be protected from disclosure in litigation by legal advice privilege. But the shareholders relied on the shareholder rule, which Peter has just outlined, as an exception which overrides privilege, where, as here, the party seeking disclosure is a shareholder in the company. Now, the court at first instance in Bermuda and the Bermuda Court of Appeal both held that the company was not entitled to maintain legal advice privilege as against the dissenting shareholders, essentially relying upon the shareholder rule, finding that because the parties seeking disclosure were shareholders at the time the advice was obtained, they were entitled to see a copy of that advice in subsequent litigation involving themselves and the company. It was common ground in that case that there was no prior independent Bermudan authority on this point, and that if the shareholder rule formed part of the law of Bermuda, it did so because it formed part of English law. So when the company appealed to the Privy Council, which is the ultimate appeal body for Bermuda law matters, the company appealed not only against the application of the shareholder rule in Bermuda, but also argued that it should no longer be recognised as part of English law, essentially a belt and braces approach to the arguments. So that's how litigation originating in Bermuda and concerning Bermuda corporate law has come to be of such significance to the law of England and Wales. So just before we move on to the arguments before the Privy Council and the decision that the Privy Council made, it's worth noting that by the time the case reached the Privy Council, certainly the traditional status-based shareholder rule was already on the ropes. And that's because in 2024, the English High Court, in the case of Abar Holdings and Glencore, had already concluded that the shareholder rule should be abandoned. However, in that case, the judge, Mr. Justice Picken, recognising the significance of this decision, did grant permission to appeal and authorised a leapfrog appeal to the Supreme Court, essentially to determine this point once and for all. However, the Supreme Court declined the leapfrog appeal, so it essentially refused to hear it at that point, on the basis that the issue was likely to be resolved in any event in this case before the Privy Council. So it was down to the Privy Council in this case to decide the fate of the shareholder rule. So moving on to the next slide. So what was the Privy Council deciding and what was its decision? So the Privy Council had before it three arguments for the existence of the shareholder rule. The first is what we call the original status-based rule, which relies on the proposition that a company cannot raise legal advice privilege against a person who was a shareholder at the time the relevant advice was given, because as Pete has explained, on the basis that essentially that shareholder has ownership rights or rights akin to ownership rights in relation to that advice. However, and as Pete has already hinted at, that idea has already been thoroughly debunked, given the developments in English corporate law over the last century and a bit. So this idea was given short shrift and rejected by the Privy Council. And the Privy Council said this. It said, the status-based automatic shareholder rule is therefore now, and in truth always has been, a rule without justification. Like the emperor wearing no clothes in the folk tale, it is time to recognise and declare that the rule is altogether unclothed. And what the Privy Council is really getting at there with the analogy with the emperor's new clothes is that a shareholder rule based on the idea of a shareholder having a proprietary interest in legal advice obtained by a company has lasted far longer than it really should have. English law has long since moved on from the idea of shareholders having ownership rights in the company's property, and English law really should have spotted and addressed this anomaly before now, hence the analogy. So the second basis that was relied upon and which generated quite a lot of the argument in the case, and that's very much in anticipation of that status-based justification being rejected. The argument here was that rather that the shareholder rule should actually be seen and should be retained in modern corporate law as not based on ownership rights, but in fact as a version of joint interest privilege. And the argument here is that the company shareholder relationship is one of an established group of relationships where joint interest generally exists. Pete's already referred to the relationship between trustee and beneficiary, where a trustee is basically their sole purpose is to act in the interest of the beneficiaries. Another example would be principal and agent, and those historically have attracted a joint interest privilege. And the argument here was that the shareholder company relationship should fall into the same category. But again, the Privy Council rejected this argument. In particular, the Privy Council had two difficulties with this. One, the Privy Council observed quite rightly that this is not how the rule originated. This is something of a backfilling once the sort of ownership approach falls away. But more importantly, in declining to sort of substitute this new reasoning for the shareholder rule, the Privy Council relied upon the fact that very often, in fact, the interests of a company and its shareholders are not necessarily aligned. Firstly, shareholders themselves are not a homogeneous block whose interests are all the same. Different shareholders can and do have divergent views as to what success looks like for the company and how it ought to be achieved. And secondly, the interests of shareholders are just one factor that the directors of a company have to take into account. And those interests may differ from, for example, the interests of a lender to the company or the company's employees. And where those interests diverge and a company is seeking to balance those interests, it needs to be able to take legal advice to protect the company's position. And in that modern context, a broad-based exception to legal advice privilege, which allows shareholders access to the company's legal advice on the basis that the company and shareholders have a joint interest, would potentially discourage a company from going and obtaining the advice that it needs. So that argument was also rejected. And that really brings us on to the third argument, which was a sort of a slightly more nuanced version of the joint interest argument. And what the shareholders argued here was that even if there is no broad-based shareholder rule based on joint interest, the company-shareholder relationship is essentially a gateway which allows and requires a court to consider whether, on the facts of any given case, the interests of the company and the shareholders are in fact sufficiently aligned that a joint interest exists and the shareholder rule should be applied. But the Privy Council emphatically rejected this argument as well and actually described this possibility as even worse than a broad-based rule, essentially because of the uncertainty that it would introduce. So the Privy Council took as its starting point the idea that the purpose of privilege is to encourage parties to take legal advice. And it observed that in order for privilege to deliver its intended objective, there must be reasonable certainty as to whether it will or will not apply on a particular occasion for the taking of legal advice. And the Privy Council's view was that a circumstance-based application of the shareholder rule would introduce intolerable uncertainty, which would make it very difficult in some cases for a company to be able to confidently go and seek the advice that it needs. So overall, the Privy Council arrived at quite an emphatic rejection of the shareholder rule in all its guises. And the Privy Council went further and made what is known as a Willers and Joyce direction. So although this case originated from Bermuda and Bermuda corporate law, much of the argument really had been about the justification for this rule as a matter of English law from which it had been imported into Bermuda. And so the council made what's known as a Willers and Joyce direction, directing that the courts of England and Wales ought to regard the shareholder rule as having been essentially abolished for the purposes of litigation before those courts. So that's an overview of the issues in the case and the council's reasoning and decision.
Thanks very much, Jared. Before I move over to Pete, we have got a couple of questions in the question and answers section. Please, if you've got any questions burning in your mind, then post them there. We've got a lot of people here attending live, so pop them in and we'll try and pick them up at the end. So moving on to the next section, Pete, more practical examples. What does this mean for companies? What does this decision mean for companies?
Well, hopefully it's clear from what's been said so far that the decision in Jardine is significant. Whether or not it's welcome or unwelcome probably depends on your perspective. In reality, the shareholder rule was a significant weapon in a shareholder's armoury in disputes with the company and its directors. That's because it enabled a shareholder to get privileged documents belonging to the company. And obviously, those documents could be the source of damaging material to the company's interests in the claim. But the companies couldn't do much about it because of the application of the shareholder rule. Jardine's flipped that on its head, and generally the consensus is that the decision could be a significant obstacle for shareholder claimants pursuing claims against companies, especially perhaps in securities litigation, where legal advice has been taken in relation to announcements to the market and such like. All of that would have formally been disclosable under the shareholder rule. So one can see that those types of claims have suddenly become probably much more difficult, at least from an evidentiary perspective. On the other side of the fence, directors of companies that are facing litigation or perhaps dealing with activist shareholders will no doubt welcome the decision. just as important as thinking about what this decision means is recalling what it does not change. And I'll just finish by noting that Jardine simply confirms a company's entitlement to assert privilege against its shareholders. And in effect, it restores its right to claim privilege in relation to legal advice that's been paid for by the company.
Thanks very much, Pete. Just before we finish up, then, is this all good news? Does this mean that a company will never need to disclose legal advice to shareholders in litigation?
Thanks, Craig. No, it doesn't mean that a company will never need to disclose legal advice to shareholders in litigation. What it does mean is that shareholders no longer enjoy sort of an enhanced position of having an automatic exemption from legal advice privilege when they're in dispute with a company. But that doesn't mean there will never be a route to obtaining disclosure of legal advice given to the company. So following this decision, if shareholders are in dispute with a company and it is important to them to seek to get hold of legal advice given to the company if they consider that it may be critical to their case, they essentially are now in the same boat that they would always have been in without the shareholder rule, which is that they will have to consider whether they can rely on any other routes to get sight of that legal advice. And in particular, you're really looking at the sort of established exceptions to legal advice privilege. The exceptions to legal advice privilege are a whole webinar on their own, so we're not going to go into too much detail here. But in that situation, shareholders need to be getting advice essentially as to whether there may be routes, whether there may be exceptions to legal advice privilege that apply that mean that they may be entitled to see that advice, notwithstanding that it would ordinarily be treated as subject to legal advice privilege. So we've got a few of the exceptions on there that might be relevant in a dispute between a shareholder and a company. So the first one, which is one that's always worth considering, is waiver. So where a party benefiting from legal advice privilege, so in this case, a company, has waived that privilege, it can no longer rely upon it. And there are a range of different ways that a party might be said to have waived privilege, but generally speaking, what you're looking at is a situation in which the company has already effectively relied to its benefit on that advice in the dispute. So if, for example, a company has in its communications with shareholders referred to legal advice it's received as justifying a particular course of action or having had certain effects, that might be sufficient to amount to a waiver of legal advice privilege, which would allow the shareholders to basically seek sight of the advice itself rather than just having to accept what the company tells it about what that legal advice means and what its ramifications are. Another exception which is worth keeping in mind is the iniquity exception. So there's no privilege in documents which are brought into existence as part of or in furtherance of wrongdoing. And of course, in a dispute between shareholders and a company, there may well be allegations of exactly that. There may be allegations by the shareholders that the company or its officers have been involved in wrongdoing to their detriment. So where a company or its directors have obtained legal advice as part of or in support of conduct which the shareholders allege constitutes a criminal or a civil wrong, including breaches of duty, they may be able to argue that that advice does not actually attract legal advice privilege in a dispute with the shareholders. And the final one that I think is worth keeping in mind here is what's known as joint retainer privilege. Obviously, we've discussed in this webinar the idea that shareholders can no longer assert a shareholder rule on the basis of joint interest privilege. Nevertheless, they should consider whether joint retainer privilege applies, and that is essentially where more than one party is deemed to have been the recipient of legal advice. And obviously, I think particularly, not so much in a big case, a big multinational case like Jardine, but where you're dealing with a small company where there may be a relatively small number of individuals involved, perhaps wearing multiple hats as shareholders and directors, it may be that on a proper analysis, a shareholder was in fact one of the parties who instructed or paid for or obtained the advice, and therefore are entitled to see it on the basis of joint retainer privilege. So that is also worth considering, especially, as I say, when it's a relatively small company with a relatively limited number of sort of people involved. Nevertheless, those are all very much exceptions to the general rule protecting legal advice, and to which shareholders now, in light of this decision of the Privy Council, they now find themselves subject. So there is no doubt that, notwithstanding those remaining exceptions and routes that shareholders should consider, this is a real end of an era as regards shareholder access to a company's legal advice in litigation between a company and shareholders.
Thank you very much, Jared, and thank you, Pete. We're now going to offer up the floor to some questions. We've got a couple. If any are coming to mind, then please feel free to stick them in the chat function, and we'll pick them up or follow up with you to address those if we've not got time. One question here is, how can companies mitigate the risk of waiving privilege? Do either of you want to pick that one up?
Yep.
How can companies mitigate the risk of waiving privilege?
Well, I think it's all about maintaining confidentiality of communications or documents which contain legal advice. That's a simple piece of advice which we always look to give to our clients. So I'm talking about controlling the internal distribution list for privileged information. Avoid commenting on legal advice substantively in emails. So that's quite a common issue. A piece of advice is coming to the company from the company solicitors, and employees, team members go on and share that more widely, referring to the content of the advice. That normally results in a waiver of privilege. Another way to mitigate the risk is to keep the pool of people that receives legal advice as small as possible, and ensure that any written discussion of that advice is only within that pool of people and on a need-to-know basis. That's what I would say.
Yeah, that's good advice across the board, isn't it? But in particular in relation to this scenario, it's very opposite. We've got one further question. How does the new landscape compare with other legal jurisdictions? I'm not sure if either of you are able to field that. How does the new landscape compare with other legal jurisdictions?
Yeah, I'll take that one, Craig. Actually, the judgment itself looks at this. Obviously, the Privy Council was aware that it was dealing with a very, very long-standing rule that people have relied on for a long time, and therefore was reluctant to get rid of it without sort of turning over every stone for possible justifications, essentially. So one of the things that the Privy Council's judgment does do is look at how other jurisdictions have approached this issue, and one of the things they observe actually is that this rule, if anything, England and Wales, the law of England and Wales is something of a laggard in the way it approaches this. It did identify a couple of jurisdictions which do still apply this rule, such as the Cayman Islands, but it did observe that that they were only doing so very much as an import from England and Wales. The Privy Council looked at the treatment of this rule in Canada and Australia. I think it was just those two that I recall, and certainly I think Canada has moved on. It has long since sort of effectively reached the same conclusion as the Privy Council has now, that actually there is the historic justification for this rule doesn't really stand up to scrutiny. I think Australia has still applied it, but only on the same grounds that the Privy Council has now debunked. So I think if anything, the Privy Council took some comfort from the fact that other common law jurisdictions who had received this, who perhaps inherited this rule from England, had long, perhaps in some cases long since reached the conclusion that the Privy Council has. So actually, if anything, this judgment is bringing English law more into line with sort of common law consensus.
Great, thank you very much. That's the only questions we've got. So on behalf of myself, Jared and Peter, thank you very much for joining us.
Thank you.